What exactly do we mean by an error that is apparent on the face of an award? Well, this is not difficult to understand at all. Let's say that you buy a used mobile phone, and when you buy that mobile phone, then on the face of it, that is superficially, when you inspect that mobile phone before paying the price for it, you cannot see any obvious defect. That is, on the face of it, it appears to be perfectly fine. However, you have not as yet used the mobile phone, so any defects that are not apparent on the face of it, that is, those defects within the mobile phone that are not going to be obvious to you when you buy that mobile phone and while you are physically inspecting that mobile phone before paying the price for it. So those defects that you cannot see, those defects that are not obvious, those defects in the mobile phone that are not visible to your eye are going to be called as latent defects, that is, defects that are latent and not patent. So patent and latent are essentially opposite words, and patent means those defects that can be seen on the face of it, while a latent defect is one that cannot be observed with the naked eye. So in short, a patent defect is an obvious one, while a latent defect is usually a hidden one, that is, something that is not obvious. So when we talk about an error that is obvious on the face of it, that is an error that is apparent on the face of it, then we are referring to essentially patent errors and not latent errors, obviously. Now let's talk about this example in the context of an arbitration award. Even though I would like to make it clear right away that this analogy may not be perfectly suitable, however, I'm using it by way of an example so as to make things easier for you. So, let's say that an arbitrator has passed an award and one of the parties is obviously not happy with the award. And of course, it is also possible that it's not just that one of the parties is not happy with the award, but that in fact there are good reasons for the award to be set aside. That is, one or more of the grounds laid under Section 30 of the Arbitration Act are in fact satisfied so that the award should indeed be set aside. So in this particular situation, when an application is filed under Section 30 for setting aside an award and the arbitral award, that is the arbitrator's award, comes before the court, then the court is just going to restrict itself to inspecting the award itself. Now, remember, I said earlier in the previous lecture that the court is not going to be looking into the evidence based on which the arbitrator passed the award, but is instead going to be looking only at the award itself. So the point is that the court is only and only going to restrict itself to examining, that is, reviewing the award itself, and unless and until some problem, that is some sort of error, is obvious on the face of the award, that is some sort of error is standing out from a mere look at the award, only then is the court actually going to consider going further than the award itself. So let's say that on the screen you can see that there is an arbitral award that's lying right in front of the court. So normally when an application is filed under Section 30, the court is just going to be looking at this particular piece of paper, that is the award itself. Then the court is not going to proceed to scrutinize the award simply in order to discover an error for the purpose of setting it aside. That is, the court is not going to be engaged in any sort of scrutiny of the award merely to find a reason to set it aside. So as long as there is no error apparent on the face of the award and there is no error that can be discovered simply by seeing the award itself, then no scrutiny is going to take place. That is, the court is not going to start examining the evidence which was presented by the parties before the arbitrator and based on which the arbitrator gave the award. So remember that as long as whatever is written in the award itself does not give any reason to the court to inspect the reasoning process behind the award, then the court is not going to interfere with the final decision of the arbitrator. So the key point to understand is that on an application under section 30, the court is simply going to restrict itself to examining, that is reviewing the award itself. So all that the court is going to look at in order to see whether or not there is any discrepancy in the award is to look at the award itself, and the court is not going to travel outside the award in order to find out what evidence was brought by the parties before the arbitrator, and then whether or not the conclusions, that is the decisions of the arbitrator, are indeed based on sufficient evidence. So this is not something that the court is going to do when an arbitral award is brought before the court. The court is only and only going to examine and review the award itself, and I repeat, the court is not going to discuss or investigate anything that is not mentioned, that is not set out and discussed in the award itself. Now this is extremely important. Why? Because it has been held in many cases, so that it is now a settled principle of law that it is possible that the court itself may have reached a different view, that is the court itself may have reached a different conclusion if the same case had been brought before the court. However, that does not mean that the court is actually going to check in each and every arbitrator's award whether or not the arbitrator reached the right or the wrong conclusion, because this is not a matter which is open for consideration by a court, because like I said earlier, the court is not acting as an appellate court. So the court can strictly not constitute itself into a court of appeal whenever it is reviewing an arbitrator's decision under section 30. Now this is extremely crucial. Why? Because it is very much possible that if the court actually decided to discover whether or not there was an error in the reasoning process, that is, if the court undertook a scrutiny of any material beyond the award, that is, the court does not restrict itself only to the award itself but goes beyond the award in order to find out how the award was reached, then perhaps the court may indeed find some sort of error, some sort of defect with the arbitrator's award. However, this is precisely what is not permissible, that is, this is precisely what is not permitted under section 30. So to sum up and to put it very simply, the court can only look at the award that is lying in front of the court, that has been brought before the court, but the court cannot go beyond the award in order to discover an error. And it is an established position in law that an arbitrator is the sole judge of facts, and even though the court may itself have come to a different conclusion, that does not mean that the arbitrator's decision will be set aside.